A series of events has been set in motion which could, in theory, lead to the impeachment of President Cyril Ramaphosa over the Phala Phala farm saga, although experts say it's highly unlikely to go that far. Last week, the National Assembly Speaker, Nosiviwe Mapisa-Nqakula, announced that a motion by the ATM party calling for the impeachment of the president would be referred to an independent panel to assess whether there does seem to be a case for the removal of the president. Once that panel does its work, the next step will be for the National Assembly to decide with a majority vote whether or not an impeachment committee should investigate Ramaphosa. If the committee recommends his removal, a two-thirds majority would still be required to vote to see him actually impeached. Professor Pierre de Vos has written an opinion piece saying that impeachment is highly unlikely, but the process may shed some details on what happened at Phala Phala. Well, Professor Vos is the UCT Claude Leon Foundation Chair in Constitutional Governance. Professor, thank you for being with us. You've explained that the process became a little more complicated after things changed in 2018. So you say the Speaker had no choice but to appoint this independent panel of experts. There are a whole lot of names being bandied about, judges, advocates. Just tell us who these three people are likely to be and what they're going to do.
Well, of course, I have no idea who they are likely to be. The rules of the National Assembly says that collectively this panel must obviously be independent, they must be impartial, and collectively they must have the requisite legal skills to be able to make these kind of assessments. Their job is to see whether there's sufficient evidence to support a finding that the president is guilty of serious violation of the constitution or the law or serious misconduct. So in the past, in the previous round, when such a panel was appointed for the removal of the public protector, which follows more or less the same process, a retired judge was headed this panel, and then two senior legal representatives, advocates, were also on the panel. So if the same process is followed, and we will see what the political parties say, they can give an input into this panel, it will have to be appointed. Lots of speculation about former Chief Justice Mogoeng, Justice Jafta, a retired Justice of the Constitutional Court, but of course we don't know to what extent these speculations are based on fact.
I mean, if the Chief Justice Mogoeng is appointed, would that be ironic? I think you say that he didn't like the law changing. He was talking about a judicial overreach in that case.
Yeah, I haven't thought of that actually, but it would be a bit ironic. I doubt whether he will be appointed just because there's been reports or speculation that he might join the political party fray. So that might not make him ideal for the position. It would probably be better for somebody who's one step removed and has not been involved in any of the debates and discussions about the president, the opponents of the president, and so on.
People are trying to understand, because the Phala Phala case has not gone through the courts, so Parliament is not waiting for that. Does this panel have to decide if he could be found guilty in a court of law, or looking at what the Constitutional Court would say, or is the bar lower? Maybe he was just being dishonest.
Well, the panel is not obviously a court. It cannot do a finding of guilt or not. It has to assess whether there's sufficient evidence. In other words, there must be evidence at least that a reasonable person from which a reasonable person could conclude either that there was a serious violation of the Constitution, not upholding the president's oath of office or whatever, a serious violation of the law, so breach of the corruption law, the exchange controls law or whatever, or serious misconduct, the president acting in a way that is completely incompatible with his office. So that assessment is more of a factual assessment using the facts, and it's only the facts that are presented to the panel by the complainants and other members of the National Assembly. There won't be any oral hearings or the kind of procedures that we have seen in the Zondo Commission and that we are seeing now in the removal of the public protector, the hearing in that case.
Even if this panel finds there is enough evidence, then it goes to the National Assembly for a majority vote. According to reports, 31 ANC MPs would have to vote with the opposition. So that's pretty difficult. Then there's still another process and another vote which requires a 2/3 majority. So that's why you're saying this is basically impossible, that the president won't be impeached in your view.
Well, as long as the president is the president also of his party and remains in control of the party, we know from all previous cases that members of parliament they are under party discipline, and they by and large follow party discipline and they follow the party instructions, and the party will at some point, at least at the final vote, which is a purely political vote when the whole National Assembly votes, they will instruct the MPs not to support the motion. So unless it's a secret ballot and unless many ANC MPs vote for the motion in secret, it is not going to happen for as long as the president is also the president of the governing party.
All right, but you do say we could get something out of this. Let's just look at what's on the table. The former spy boss Arthur Fraser submitting evidence at a police station. What's not in dispute is that money was taken from the president's farm. What is in dispute is the claim that this was some form of money laundering and the president was involved in the kidnapping of those robbery suspects, then bribing them apparently not to report the crime they committed. He's also accused of breaching SARS rules and the Prevention of Organised Crime Act. So are you saying he would have to respond more robustly to the panel, or if there was that later panel with oral hearings, he would have to respond much more robustly than he has to us regarding media requests, say?
Well, that is the hope. Before the rules were changed, of course, what happened with these impeachment motions, it went to the National Assembly. There was a big political speeches were made, and then there was a vote. So there was no requirement to actually establish what the facts are. Now the rules require this panel as a start to see if there is evidence. If the parties who made the complaint and want the motion to proceed, if they presented at least some credible evidence that there was wrongdoing of some kind, the president, I think, would have no choice but to respond. And so in that process, at least, we will have some accountability, because even if the president responds in an evasive manner, that is also a kind of revealing accountability. And so that process alone is a kind of disciplining process that is not, we don't always see in the more political aspects of the National Assembly's work, where political party members tend to protect their own and protect their leader. This process is slightly more like a quasi-legal kind of process, and so it will really depend on what evidence is put before the inquiry, independent panel, and how the president responds. Of course, that is also then something that will be made public, and then voters, as always, will be or not be influenced by what they hear from the process.
All right, so at least we may have a little more information. Thank you very much for your time this late afternoon. Professor Pierre de Vos, UCT Claude Leon Foundation Chair in Constitutional Governance.